So good day. In today's presentation, we shall be looking at causation. Causation. This is the first of a series of presentations on causation in the thought of negligence. Causation in the thought of negligence. Today's video will focus specifically on factual causation, and it shall be looking at the general rule regarding factual causation. The general rule, the but-for test. I want to sensitize us to the fact that in the thought of negligence, of course, we have looked at the fact that there must be a duty of care, there must be a breach of duty, and there must be damage. Having um, realized that, one of the things that must be noted is that the question of causation must be examined in most cases that deal with the thought of negligence. Causation is divided into causation in fact and causation in law. But for clarity, let me stand and emphasize the fact that essentially, when you look at your text or arguments or articles, you see discussions like causation in fact, causation in law, or legal causation. Then you have discussions that focus on aspects of it, like looking at questions like um, Lupus actus intervenis, what we call a break in the chain of causation. Then we talk about res ipsa loquitur. As the videos are uploaded, we'll be emphasizing the place of all these in the scheme of causation in thought. But for today, we'll focus on causation with respect to factual causation. And as usual, we shall be looking and sharing the screen. Now, when you talk about factual causation, what are you looking at? What are we looking at? Okay, so we're looking at factual causation, and in this respect, would we would like to examine the narrow question that the law tries to answer in factual causation. Because like I said, we have position in fact, position in law. The essence of factual causation, let me share the screen. The essence of factual causation is that you want to ask some basic questions. I haven't said that this thought has committed because the defendant has breached their duty of care. You're trying to find out, are we sure is the defendant that's actually responsible for the injury that has taken place? So we are trying to understand the significance of factual causation in this respect, that the defendant that is before the court, is he the one that should be held responsible for the injury that you are complaining about? For the injury that you are complaining about. And in this respect, we will be applying the but-for test, the but-for test. That test gives the court direction in majority of cases, but there are situations where it will not be helpful. In subsequent videos, we'll be looking at that. So causation, essentially, before we focus on factual causation, causation is essentially you try to find a connection between the breach of duty by the defendant and the injury to the claimant. The breach of duty, the nexus, the connection. Okay, the claimant is claiming that because you have exposed him to dust, you have exposed him to some chemicals, he has suffered cancer. Is there a connection between that exposure and the cancer? That is one aspect that you are looking at in terms of causation. You're also looking at, oh, this exposure to cancer, this dust that you have exposed into, is this the plaintiff that actually exposed him to it? Or is there another defendant that should be sued? So that's another aspect of causation that's called factual causation. And essentially, the rules are quite varied. I must send it to warning. They are quite varied. And specific rules are applied to specific situations in different contexts. Now, two forms of causation that we've talked about. We said there's a factual causation and there was legal causation, or causation in fact and causation in law. In causation, you try to answer these questions that have been formulated in Wallace and Camp, that you try to determine the purpose. Who should you attribute responsibility to regarding the injury to the plaintiff? Who should you ascribe legal responsibility to? And in that premise, two questions come before the courts. You want to find out, as a matter of historical facts, how did the harm occur? That is the question that factual causation focuses on. How did it happen? In the history, in the story behind this broken leg, is there any role that the defendant has played? Is there any role that the defendant has played? As comments the inquiry. Then there is a normative question as to whether legal responsibility for that particular harm occurring in that way should be attributed to a particular person. Should you ascribe it? Okay, X was involved in an accident in which Y negligently drove and caused personal injury to X. X is taken to the hospital. While X is in the hospital, and armed robbers came to the hospital and attacked patients, and X was killed. Should Y, who initially caused the injury to his leg, who initially caused personal injury, be held responsible for everything that has happened? Or should his responsibility be limited to the fact that he suffered personal injury, and anything that happened after that should be ascribed to the act of a third party? So those are some of the questions we'll be looking at as you progress. Now, for factual causation, now that we are focusing specifically, you look at the storyline. In the storyline that leads to the death of X, is there any role that Y played? When you look at that example, factually, if Y had not injured X, X will not be in the hospital, will not be subject to that attack. Factually, Y caused the injury to X. Factually, there is a place in the storyline, there is a linkage between the act of Y and the eventual injury to X. So you trace the steps, you track the story, you see the trend, and you try to rationalize and project and speculate. What is X doing in the hospital in the first place? If not for the injury to him that was caused by Y. Now, let's go forward. The general test that has been developed for this inquiry is what is normally called the but-for test. The but-for test. And it requires that you ask the question, would the claimant have suffered the harm he did suffer, but for the defendant's fault? But for the defendant's fault. In other words, if you give the answer, no, he would not have suffered it, the defendant is the factual cause of the injury. In the example that I gave just now, the Mr. X would not have been in that hospital to be shot by robbers, for instance, if he was not initially injured. So the breach of duty by Y is the factual cause of his death, the breach of duty. But like I said, the inquiry does not end there. After you have answered that question, then you say, should law make Mr. Y legally responsible for that shooting that caused his death? That's another cause of inquiry that we'll be talking about later. So you can ask that question again and say, we can answer and say, yes, he would have suffered it. He would have suffered the harm without the defendant's breach of duty. That is, if you remove the breach of duty by the defendant, he will still have suffered it. The defendant is not the factual cause. Don't forget that I keep saying this factual causation, the fact that he is not responsible legally is a different matter. So the but-for test can also be put in this format. Would the plaintiff's laws have occurred in any event without the defendant's breach? In any event without the defendant's breach, yes, it would have occurred. Then defendant is not liable, and that is the end of the matter. Would Mr. X have been on that hospital bed without being hit by Mr. Y at that particular point in time? Yeah, if the answer is yes, it would have been there because of some other thing that happens. Then your inquiry takes a different connotation. Now, in formulating the but-for test, therefore, you can argue and say, if you can show that it was inevitable that that same harm would have occurred, where the defendant's act is expunged, is removed from the sequence of events, defendant will not be the factual cause of the harm. If you say, okay, the breach of duty of defendant, let's take it away, let's expunge it, and let's look at the storyline. And you see that when you have removed the defendant's breach, the result will still have been the same. The defendant is not the factual cause. Now, let's take our cases, because for tort law, you need your cases to foil the principles. In Cook against Kirby and McLean, where a factory worker fell off a platform that was about 23 feet high, and he died. How did he fall? He had epileptic seizure. The employers were not aware that he was epileptic. He fell when he had his seizure. The platform did not have any guardrails to protect, to prevent the fall. So when he fell and he died, the employers argued, when the action was brought by the estate, and the employers argued that their breach of duty, as an employer, they had a statutory duty to provide a safe system of work and safe place of work for their employee, and which required, therefore, that they put guardrails to prevent a fall. So they had breached that statutory duty. There was no doubt about it. But their argument was that factually they were not the cause of the death, that the cause of the death was the epileptic seizure. The court, then had to look at the issue of the but-for test to see if this breach of duty was the cause of the death. And the formulation of the but-for test is interesting. It says if the damage would not have happened, but for a particular fault, then that fault is the cause of the damage. If it will have happened just the same, fault or no fault, the fault is not the cause of the damage. So what is the damage here? Let us apply it. Okay, the death of the deceased is the damage. Would he have died if there were guard railings? Would he have died? He definitely would have had the epileptic seizure, but would he have died? And the court said he probably would not have fallen off. He would have had the seizure, but he would not have fallen off the platform. So the guardrails would have stopped the fall. So it was the breach of their duty that caused the fall to his death. And therefore, the defendants were the factual cause of his death. Let's look at Barnett and Chelsea and Kensington Hospital Management Committee, the lowest class courts. The defendant's husband had presented to the hospital with complaints of vomiting and stomach pain. He was not attended to by the nurse. The doctor too was indisposed, was not available, was told to see his GP in the morning. The defendant died the following day. And the question was whether the breach of duty of the hospital. What is the breach of duty here? The breach of duty in this context was the failure to treat the patient. The hospital owed him that duty of care. But was it the cause of his death? Now, the evidence revealed that he was suffering from arsenic poisoning. At the time the case was decided, there was only one antidote for arsenic poisoning. It was not easily available. And the facts revealed that even if it was available, the quantity, the depth of the poison was such that at the time he presented, that antidote would not have helped. So the court held, would he have died even if he had been treated? That is, even if there was no breach of duty. And the facts reveal that he would still have died, even if they had given him the antidote. So it was not the breach of duty that killed him, it was the arsenic poisoning. You also have similar situations in Williams against Williams, where a steel erector fell to his death at work. And the employers argued and said that the evidence revealed that they did not give him safety harness that would have stopped his fall. But they brought evidence to show that even if they had given him, he would not have worn it, not have used the safety harness, because in the past he had not used it. So it was probable. And when it comes to this area, the court usually treats what is probable as certainty, that he would not have used it, even if it had been provided on the particular occasion that we are talking about. So the breach of duty, failure to provide safety harness was not the cause of his death. He would still have died anyway. You have other cases that you can look at. And a very interesting example is the example given by Lord Hoffman in what we call the sample case, an engineering, a mountaineering example, where Lord Hoffman gave an example of factual causation that peradventure someone is about to go on a mountaineering trip, and he went to his doctor to find out if he was fit to go. His legs are okay, everything, and the doctor certifies that he was fit. Meanwhile, it was not, the certification was not properly done. And it goes on that engineering trip. And there is an earthquake, for instance, and he falls to his death or is injured. So he falls and is injured. The doctor, the factual cause of his injury. That case, we'll be looking at it even in more detail in the subsequent presentation to distinguish between factual causation and legal causation. Put that at the back of our minds. Now, the but-for test uses something that we call balance of probabilities approach. And this is a typical approach in civil cases, in tort. Normally when you are able to prove that on a chance of 51 to 49%, for instance, the plaintiff will succeed in the matter. So if it's on that premise that the court would hold that if it was more probable than not that a damage would occur, the probability will be treated as certainty. To be treated as certainty. And in determining what would happen in the past, I mentioned the case of Williams, where the court said that, look, since the person in the past had not been using the safety harness that is provided, it was more probable that on that particular occasion, he would not have used it. So that probability was treated as certainty. Now, you have other cases that explain this issue of but-for test. One of the things that the courts have grappled with is the fact that when you have multiple causes, the but-for test may prove inadequate. Because if you apply the but-for test, for instance, each cause to be excused on the basis that the other cause would have occurred, and the defendants responsible for that may not therefore be liable. Now you have the case of Wilsex against excess area health authority and Bonitting case against Bonitting case limited against Wadlow. And we'll be looking at these cases to help discuss the principle that we call material contribution to injury. In Bonitting case limited against Wadlow, the plaintiff, so contracted pneumoconiosis. Pneumoconiosis, a lung disease, because he had inhaled those particles from the company that he was working in, his steel production company. And the sources of the dust were twofold, from a swing grinder and a pneumatic hammer. Now, under the law, the defendants, his employers, had a duty, statutory duty, to provide ventilation for the swing grinder, but they did not provide that ventilation. But they had no duty for providing ventilation to the pneumatic hammer. So the source of the injury would be the swing grinder or the pneumatic hammer. Scientifically, it was not possible to determine what is the source, and but the court held that, contrary to the arguments of the defendants, that their breach of duty, failure to provide it for regarding the swing grinder, was not the cause of the injury, since it was 50% chance on each occasion. We have two items that would have caused the inhalation. So they tried to argue that their breach of duty was not the cause of the death of the lung disease. And the court held that in these cases, you don't have to prove that your negligence is the sole cause. Once there is evidence that the breach of duty of the defendant was a material contribution to the injury, in which case there's a 50% chance that, or a 50% contribution to the source of the injury, defendants were held liable in full for the entire injury. This position of Bonington case has further been redefined in BAE Systems Operations Limited in Konzak, where the courts applied proportional liability to facts that are similar, to say, okay, you can be only responsible in proportion to the exposure that you have given to the plaintiff. For instance, 50% in castings. Now, the issue of material contribution, you have discussions regarding what is substantial. You have Carter and University of Exeter, we talked about exposure to asbestos as, from streams of employers, and that someone that had 2.3% contribution as substantially contributed, materially contributed to the injury, and other cases. In Wisha and Excess Area Health Authority, you also have a situation where the plaintiff sued the hospital, the health authority, because their staff had inserted catheter into a vein instead of an artery of a premature baby. And because of that, the baby received too much oxygen, and the facts reveal that the baby was suffering from blindness. That blindness would have arisen from the fact that the catheter was inserted into the vein. It could also have arisen from 4 other causes that were brought before the court. So there were 4 possible causes of the blindness. And so that meant that only 20% likely that defendant's negligence was the cause of the blindness. These are cases that are determined based on the fact that there are no scientific evidence as to which of these causes is the cause of the injury. The court held that the defendants were not liable. In summary, the laws of causation are a necessary component of the tort of negligence. After you have established the breach of duty, you must show that the damage that has taken place can be ascribed to the defendant. You have the factual causation and the legal causation. The causation, therefore, the factual causation tracks the relationship between what the breach of duty is and the damage to the plaintiff. What is the connection? What is the causal link? What is the historical link between what the plaintiff has done and what has happened to the defendant? Between what the defendant has done and what has happened to the plaintiff. The general rule is to use the but-for test. And The case that is very important for us is Barnett against Chelsea and Kensington Hospital Management Board, which showed that the plaintiff still applied. Plaintiff, he would still have died if he was attended to by the hospital. Definitely, therefore, the breach of duty in the hospital in not attending to him was not the cause of death. And then you have Kirby and McLean as well. In using the test, the courts have decide on a balance of probability. And what is more likely to happen is treated certainty. Where injuries are divisible, the courts rely on the material contribution to harm principle and to make the wrongdoers liable in full. For Casting's case. In cases where harm is indivisible, the court would generally adopt the all or nothing approach. Because when you apply the but-for test to all situations, it may cause injustice in some cases. It may make each defendant escape liability by arguing that, well, if I did not do A, B would have done X. For example, if two defendants negligently run into the plaintiff in an accident and cause him personal injury, if we apply the but-for test, defendant A would say, well, even if I didn't drive and injure him, B would have driven and injured him. So I am not the factual cause of the accident, of the injury to the plaintiff. And defendant B would also argue the same way, and that would mean none of them would be responsible. Accordingly, the but-for test, very helpful in a lot of cases, may not be helpful in cases where you have more than one possible cause and defendants. And it requires further rules for purposes of liability. These further rules would be considered in subsequent videos. In the light of this, therefore, would expect that when you see your cases in the thought of negligence, you know that you may need to apply the rules of causation. I must send a note of warning that I mentioned at the beginning of the video, which is the fact that sometimes you may not need to prove causation if there are cases that deal with res ipsa loquitur. You are unable to prove the causation, but you are able to show that based on certain legal principles that we're talking about later, the fact speaks for itself. It's what we call proof of negligence. Apart from the question of causation, you may need to rely on proof of the introduction of res ipsa loquitur. The fact speaks for itself. It is after the issue of factual causation has been established against a defendant, that you now go on further to consider legal causation in law. When you say, okay, we know that in fact, this is the person that ran into the plaintiff and caused him personal injury and has caused him to be admitted in the hospital, for instance. But legally, should we hold him responsible for the fact that he was shot by armed robbers while in the hospital? So the fact that, for instance, the doctor that treated him negligently, or the pharmacist gave him a wrong drug. You know that factually, if he was not suffering from the breach of duty, the personal injury that arose from the breach of duty, he would not be in the hospital. So factually, the defendant is the factual, in the eyes of the law, the defendant is the factual cause of the injury. But legally, you have to make a further inquiry and see, but should we hold him responsible in law for wrong treatment that has caused XYZ, wrong drugs that has caused ABC? These are the inquiries that I'll be looking at under legal causation. The next video will be looking at causation, factual causation, multiple causes. Factual causation, multiple causes. And after that, we're also looking at factual causation causes that are indeterminate, that you may not be able to even determine who is the cause. And a major example of multiple causes that we talk about is situations where, for instance, somebody is hit by two defendants who shot in his direction and is hit by one bullet. Who should be responsible? Or even when he's hit by two bullets, who should be responsible? There are some of the issues that will be uh, interrogating the subsequent video.